we actually had a question from the mailbag, if you don't mind me going right to that. This comes from Sue, and she is in Canton, and she asks, what are the duties of a conservator? The duties of, well, because we were talking about that last week, so it makes perfect sense. She wants to know what the duties of a conservator are.
Well, as we talked about last week, there are two types of conservatorships. One is conservator person, and the other one is conservator of estate. So for a conservator person, your main duties are to make medical decisions for that individual who is incapacitated, the person that you've been appointed by the court to have the legal authority to make those decisions. So typically in that case, that you would be communicating with that conserved person's medical providers, and you would be making decisions about what the course of treatment should be, and giving informed consent for that, whether it was a course of treatment or it was a surgery or something like that. One thing to keep in mind with that, and this is overall with all conservatorships, either whether it's conservator person or conservator of estate, is that we are required, if we're a conservator, to use the least restrictive means, which means to the extent that that person can make decisions for themselves, that you want them to make those decisions. So, for example, when it comes to medical decisions, that you want that person to be involved to the extent that they can be involved in that in that conversation with their physician,
sure,
and also with that decision making. And so you're there oftentimes, a conservator is there oftentimes as to oversee that process and to make sure that that person is making good choices. For example, if a doctor said, you have diabetes and I want you to take this medication for the diabetes, and if the person says, yes, I'll take them, and they take those, then they are making that decision themselves. If the doctor says you have diabetes and you need to take this medication, and they say, well, no, I don't want to take that medication, then that a discussion ensues, right? That's where you might have to step in as the conservator to help them, to help convince them to make that the correct decision.
Yeah. So getting to Sue's question in terms of what are the duties and responsibilities, right? So there actually is, instructions that the probate court issues as to what conservators' roles and responsibilities are, and we have to follow that. But it's really, really important what Ned was saying in terms of the least restrictive means and how you always have to attempt to include the person in the decision making. So if you have melanoma, that, for example, so we're talking about healthcare decisions right now, a tumor has been discovered, they have melanoma, something you want to say, okay, well, this course of treatment is going to mean that you have chemo or radiation or something that is not very fun. To the extent that you can talk to that person, right, and say, what do you think we should do here? What's going on? This is, both Ned and I have had to accompany people to doctor's appointments. When we have had to be in that capacity, we're there. We're asking the questions of the doctor because we, always answer to the probate court. You talked at the last time that we were here last Saturday about family members, right? We're the ones going to the doctor's appointment, not the family members. You have to report back to them and try to be able to make sure that they understand what their parents going through. And, we talked about that fine line. It can be a fine line. So
it just makes it that much more, I don't want to say the word rough or tough to understand if you're one of their children, but you're there representing the individual who is incapacitated.
Yeah.
You're looking out for their best interest.
Mm-hmm. Yeah.
Not necessarily that of their children.
Yeah.
Is that a fair assessment?
That's very fair, because when we are acting in the role as the conservator, we are standing in their shoes. Not their children's shoes. We're standing in their shoes. So... and
let's face it, that's a conversation that they had with you, not necessarily their children. Although they could have maybe touched upon, when it's my time to, to go, or should I ever become, they may have only touched the surface with them. It's an awkward conversation to have. I understand that. But that's why you exist. This is why you do this for a living. That they would have a much more comprehensive conversation about this particular topic with you. So therefore, every nook and cranny of what they're looking for at that point in their life, right? Where their children may only know surface stuff.
Well, I think one of the issues is that most of us, if we haven't gone through this process with a parent or a grandparent or somebody else, that we have no clue what that looks like. But Marianne and I, we spend a lot of time with our estate planning clients to talk to them about what the potential issues that could occur in the future or that may be likely to occur. For example, the fact that the statistics show that 68% of us at some point during our lifetimes will have some period of incapacity, whether it's temporary or it's permanent. And so incapacity is one of the things that we speak a lot with our clients on, that what do you want to have happen in the event that you cannot make decisions for yourself? And so that's where documents such as financial powers of attorney or healthcare powers of attorney come into play. The living will, where you are planning today for something that may very well happen in the future.
Yeah.
What is the difference between a living will and a living trust?
Well, a lot. Okay, so a living will addresses circumstances when you are dying, right? So you no longer have, you're in permanently unconscious, persistent vegetative state. You show no behavioral responses to your environment, and your doctor says you are dying. That's what a living will is for.
Okay.
A living trust is a document that you create while you're living, and it's where you put your assets and you manage your assets, right? So they are very, very different documents. They do incredibly different things. And a living trust in no way really addresses, if you want to be put on life support or not. Okay. So that's what.
But interestingly, the parallel between the question regarding conservatorships and the two different types, conservator of estate, which deals with financial issues, and conservator person, that those documents kind of fall in those same categories. That the living will falls under the medical decision making, and the
financial,
the living trust falls under the financial. Because one of the really nice things about revocable living trusts is, and it's a document that is typically put in place to take the place of a will. And so one of the primary reasons why people do revocable living trusts is to avoid probate. Because if at your death, your assets that would otherwise be probate assets, and a probate asset is a solely owned asset with no beneficiary designation on it. At your death, if you have a solely owned asset, like if I pass away and I have a bank account that's solely in my name, nobody has the legal authority to do anything with that. Well, the same thing with that bank account is that if I don't have any documents in place and I become incapacitated, nobody has any authority to do anything with that account. And so that's where a conservator would come into play. With a revocable living trust, not only can it help you to avoid probate and to distribute your assets at your death according to what your wishes were, but also in incapacity that you will have named someone who is called a successor trustee to step into your shoes and to manage your trust assets for you during your period of incapacity, whether it's temporary or permanent. If it's temporary, once it's been resolved and you regain capacity, that successor trustee can step out and you can get back to managing your own assets.
Do you create a living trust as well in your practice?
Oh, yeah.
Absolutely.
We do it a lot.